Welcome to EU Privacy for All, Session 14 on GDPR, Article 10, Criminal Convictions and Offences. The final numbering of Article 9.1 on processing of special categories of personal data is Article 10. It is renamed Processing of Personal Data relating to criminal convictions and offences. This article lays down that processing of personal data relating to criminal convictions and offences or related security measures based on Article 6.1 shall be carried out only under the control of official authority or when the processing is authorized by union law or member state law, providing for appropriate safeguards for the rights and freedoms of data subjects. Any comprehensive register of criminal convictions shall be kept only under the control of official authority. As it was laid down in the draft of the 15th of December 2015, the Commission proposed two texts, a privacy package, on the 25th January 2012, the GDPR, General Data Protection Regulation, but also a directive on the protection of individuals with regard to the processing of personal data by competent authorities for the purposes of prevention, investigation, detection, or prosecution of criminal offences or the execution of criminal penalties. It shall be borne in mind by data controllers. Other key provisions in the GDPR are laid down in Recital 75. The risk to the rights and freedoms of natural persons of varying likelihood and severity may result from personal data processing which could lead to physical, material or non-material damage. In Recital 91 and Article 35(3)b, it is stressed that the obligation to carry out a DPIA derives from the processing relating to criminal convictions and offences. In Article 37(1)c, it is also reminded that the controller and the processor shall designate a data protection officer in cases of processing such data on a large scale. In Article 35, the obligation to maintain records of processing activities shall not apply to an enterprise or an organization employing fewer than 250 persons unless, among other exceptions, processing includes data relating to criminal convictions and offences. Finally, in Recital 80 and Article 27, it is recalled that the obligation of the controller or the processor not based in EU and entering the scope of this directive to designate a representative unless processing of data relating to criminal convictions and offences is unlikely to result in a risk for the rights and freedoms of individuals. What's currently in the directive? In paragraph 5 and 6 of the Article 8 related to the processing of special categories of data, offences, criminal convictions or security measures are framed. It is really in line with the GDPR final wording. Those data could be processed only under the control of official authority or if suitable specific safeguards are provided under national law. A complete register, once again, shall be kept only under the control of official authority. Finally, Member States may provide that data relating to administrative sanctions or judgments in civil cases shall also be processed under the control of official authority, and derogations should be notified to the Commission. What should accountable data controllers get prepared for? Processing data related to criminal convictions and offences only in two cases. First, when it is done in the frame and under the control of official authority. Second option, when the processing is authorized by union or member state law, providing for adequate safeguards for the rights and freedoms of data subjects. Additionally, a DPIA is needed to assess the severity and the likelihood of the privacy risks resulting from those processing. By default, a data controller should consider that no register should be held on criminal convictions and offences unless it is under the control of official authority. There is an obligation that for non-EU companies, an EU representative would be nominated. Additionally, the record of processing activities shall be maintained. And a DPO, a data protection officer, should be designated. Finally, as usual, a controller should be able to demonstrate compliance. What will be interesting is knowing more about the framing of a comprehensive register of criminal convictions by member states and by the EDPB.